Hi friends, in this video we are going to deal with the case summary of the important and latest Supreme Court judgment pronounced now in the area of constitution, that too in relation to matters involving constitutional validity of 100% reservation for local residents in district cadre class 3 and class 4 posts in the scheduled districts of the state. To know more about it, please watch the video fully. If you feel that it's useful to you, please like, share and comment, and never ever forget to subscribe to it, and further click on the bell icon next to the subscribe button.
Hello everyone, I'm Advocate Shweta Singh, practicing in Allahabad High Court. Today we are going to discuss an important judgment titled as Satyajit, Kumar and others versus the state of Jharkhand and others. The judgment was pronounced on 2nd of August 2022. In this case, the Supreme Court has quashed a notification issued by the state of Jharkhand to provide for 100% reservation for local residents in district cadre class 3 and class 4 posts in the scheduled districts of the state. The facts of the case was that, pursuant to the presidential notification, 13 districts in the state of Jharkhand were declared as scheduled areas. Thereafter, the state came out with notification directing that the local residents of the concerned districts only shall be eligible to be appointed on the district cadre class 3 and class 4 posts for a period of 10 years from the date of publication of the notification. Several candidates applied for the post and undergone the selection process. The results were published and process of appointments were initiated by the state. Candidates belonging to the non-scheduled districts who were prevented from making application for the vacancy in the scheduled districts preferred writ petition before the Honorable High Court challenging the constitutional validity of the notification and order issued by the state. The High Court held and declared that the notification, the order and the advertisement inviting the application for appointment to the post of trained graduate teacher in the government secondary schools to the extent of making 100% reservation for the local candidates and residents of 13 scheduled areas in the state of Jharkhand as illegal, ultra-virus and unconstitutional, and consequently quashed the appointments of the trained graduate teachers made pursuant to the aforesaid advertisement. The original respondents, candidates belonging to the 13 scheduled districts, preferred present appeals. The issues which were posed for consideration are whether, in exercise of powers conferred under paragraph 5(1) of the 5th schedule of the Constitution of India, the governor can provide for 100% reservation contrary to part 3 of the Constitution of India and more particularly guaranteed under Article 16(1) and 2. And whether the governor has the power to modify the relevant recruitment rules framed under Article 309 of the Constitution of India. The Supreme Court held in Chebrolu Leela Prasad Rao and others versus State of Andhra Pradesh, reported in 2021-11 SCC 401, that the governor in exercise of powers under para 5(1) 5th schedule of the Constitution can exercise the powers concerning any particular act of the Parliament or the legislature of the state. The governor can direct that such law shall not apply to the scheduled areas or any part thereof. The governor is empowered to apply such law to the scheduled area or any part thereof in the state, subject to the exceptions and modification as he may specify in the notification, and can also issue a notification with retrospective effect. The governor is empowered to direct that any particular act of parliament or the legislature of the state shall not apply to a scheduled area or apply the same with exceptions and modifications. The governor can make a provision within the parameters of amendment, modification of the act of parliament or state legislature. The power to make new laws, regulations is provided in para 5(2), fifth schedule of Constitution of India. The power of the governor does not extend to subordinate legislation. It is with respect to an act enacted in the sovereign function by the parliament or legislature of the state which can be dealt with. The governor's power is subject to some restrictions which have to be observed by the parliament or the legislature of the state while making law and cannot override the fundamental rights guaranteed under Part 3 of the Constitution of India. The governor cannot override the notification issued by the president in the exercise of powers under Article 371D. The power has to be exercised harmoniously. Such an order issued under Article 371D, not in conflict thereof. Geo providing for 100% reservation is not permissible under the Constitution. The outline limit is 50% as is specified in Indra Shavne and others versus Union of India and others reported in 1992. The notification in question cannot be treated as classification made under Article 16(1). Once the reservation has been provided to the scheduled tribes under Article 16(4), no such power can be exercised under Article 16(1). The notification is violative of Article 14 and 16(4) of the Constitution of India. The conditions of eligibility in the notification with a cut-off to avail the benefits of reservation is unreasonable and arbitrary one. Applying law laid down by the Constitution Bench of this court in the case of Chevrolu Leela Prasad Rao to the facts of present case, the impugned order notification providing 100% reservation for the local residents of concerned scheduled districts areas only can be beyond the scope and ambit of powers conferred upon the governor under para 5(1) of the 5th schedule of the Constitution of India. 100% reservation provided for the local residents of the concerned scheduled districts or area only would be violative of Article 16(2) of the Constitution of India and affecting rights of the other candidates, citizens of non-scheduled area districts guaranteed under Part 3 of the Constitution of India. The exercise of powers by the governor modifying recruitment rules 2015, which are framed under Article 309 of the Constitution of India, can be subordinate legislation and cannot be an act or the law made by the parliament and or state legislature is beyond the scope and ambit of the governor's power. This court sees no reason to take a different view than the view taken by the Constitution Bench of this court in the case of Chevrolu Leela Prasad Rao. This court also sees no reasons to refer the matter to a larger bench as prayed by some appellants candidates belonging to the scheduled area or districts. However, if the candidates belonging to non-scheduled areas or districts are given an opportunity to impart education, then it will be more beneficial to the students belonging to the scheduled areas and their quality of education shall certainly improve. The quality of education of the school-going children cannot be compromised by giving 100% reservation in favor of the teachers of the some districts and prohibiting the appointment to more meritorious teachers. Further, the impugned order notification making 100% reservation for the local resident of the concerned scheduled districts or area is violative of Article 16(2) of the Constitution of India, as it affects the fundamental rights guaranteed to the candidate belonging to the non-scheduled areas guaranteed under Part 3 of the Constitution of India. As per Article 13 of the Constitution of India, the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of Article 13(2) shall, to the extent of that contravention, be void. Therefore, also impugned notification order advertisement making 100% reservation for the local resident of concerned scheduled area and district shall be ultra vires, Article 13 of the Constitution of India, and shall be void. Even under Article 16(3) of the Constitution, it is the Parliament alone which is authorized to make any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state of union territory, any requirement as to residence within the state or union territory prior to such employment or appointment. Therefore, impugned notification order making 100% reservation for the local resident of the concerned scheduled area district is ultra vires to Article 35, read with Article 16(3) of the Constitution of India. Thus, the High Court has not erred in holding that the notification and order providing 100% reservation for the local residents of concerned scheduled district areas as being unconstitutional and ultra vires to Article 14, Article 13(2), Article 15 and Article 16(2) of the Constitution of India. It is rightly held that the said notification and order would also violate Article 16(3) and 35 AI of the Constitution of India. The High Court has also rightly held that a forced notification and order is ultra vires to paragraph 5(1) of the 5th schedule of the Constitution of India. Now, so far as the prayer made by the candidates belonging to the scheduled districts areas who were already appointed and whose appointments are held to be illegal, and their plea that the judgment of the High Court may be made applicable prospectively are concerned, the same may not be accepted. Once the notification order are held to be ultra vires, as the necessary consequences, appointments made pursuant to such unconstitutional notification or order shall have to be set aside, and such appointments as such cannot be regularized. In view of the impugned judgment and order passed by the High Court, by which the High Court held all the appointments made in scheduled districts areas illegal and has further directed to go for fresh recruitment, the state will have to undergo fresh recruitment process which may take considerable time, and in the meantime there shall be vacancies and number of schools in the tribal areas shall be without teachers. Therefore, the court has to strike a balance between the rights of the original writ petitioners as well as persons, teachers already appointed, and also the public interest. Hence, while molding the relief, instead of initiating a fresh recruitment process, if directions are issued for preparation of fresh selection list based on revised merit and based on already published cutoff obtained by the last selected candidates in each TGT subject against respective categories, It will meet ends of justice and striking the balance between the competing rights so that persons already appointed may not have to lose their employment or job, and at the same time the candidates belonging to the non-scheduled districts and area may also get their opportunity for appointment as a teacher on merits in the scheduled districts and areas. Thus, the common impugned judgment and order passed by the High Court declaring the impugned notification order as unconstitutional and ultra vires to Article 14, 16.2, 16.3 and 35 AI of the Constitution of India is upheld.